live as I do every day to talk about trademarks and copyrights and whatever else I feel like talking about. I got an interesting question yesterday from a viewer, and he wanted to know if the exact mark that I'm interested in using doesn't come up in a search, can I use it? Now, this is something I hear this question an awful lot, and people are under the mistaken impression that if your exact mark isn't found in the US Patent and Trademark Office database, that it is free for you to use. However, nothing could be further from the truth. It is not necessarily available just because your exact mark isn't in there. This is because other people's trademark rights extend beyond their exact mark and beyond their exact goods. They extend to anything that would be confusingly similar to their mark. And that is, the confusingly similar question is kind of a multi-factor analysis of the facts and circumstances of the trademark holder's use and the context of that use in the marketplace. For example, we would look at whether or not so we're going to talk about the senior rights holder, which would be the trademark owner, and we're going to talk about the junior user, which is the proposed registrant. Okay, so the senior user is the person who already has the mark. The junior the junior rights holder, is the person who is proposing to use the mark, or maybe has started to use the mark but hasn't perfected their trademark rights by filing an application and is maybe applying. Okay, so we look at the senior user's use in the context of the marketplace, and then evaluate whether the junior user's use will conflict with that. So for example, let's say that you are Tiffany and Company and you produce a whole range of goods, and your mark is really famous for jewelry and other sorts of luxury goods. And there is a junior user coming in who wants to apply the mark to, let's say, blankets. Okay. Now, Tiffany and Company, as far as I know, doesn't presently use their mark on textiles, but because it's very common in the marketplace to see companies that produce home goods like china and crystal and silver and those sorts of things, they also make soft textiles, and that's common to see in the marketplace. So because the consumer expectation in the context of the use of the senior mark holder is that it's possible for people to produce those sorts of soft goods while they, also have marks in use for china and silver and those sorts of kind of more hard goods, then the trademark office would refuse a registration that sounded like Tiffany or looked like Tiffany or was in any way related, either on a sound or a spelling basis to Tiffany, because it would tend to confuse consumers in the marketplace. A consumer might look at this, let's just say it was spelled Tiphany, Tiffany, and a consumer might look at that and say, wow, okay, so I wonder if Tiffany and Company is now producing blankets. That seems plausible, because a lot of companies that produce crystal in China also produce things like blankets and throws and pillows. So, gosh, I wonder if Tiffany is now producing these, maybe blankets or throws for your couch. So that is consumer confusion. And keep in mind that we don't have to prove actual consumer confusion when we're looking at this evaluation. All we have to show is a likelihood of confusion. In the case also of a famous mark like Tiffany, you're never going to get a registration for anything that has the Tiffany name on it, because the mark is so famous. The only reason why somebody would adopt Tiffany for anything is because they're trying to piggyback on the goodwill of Tiffany and Company and on the fame of their mark. That dilutes Tiffany's trademark and tends to prejudice them or harm them because someone else is using their name, and maybe that someone doesn't uphold the same sorts of standards and qualities and things like that that Tiffany and Company has come to be recognized for. So we always evaluate the junior mark or the junior proposed mark in the context of the existing trademark registry and the experience or expectations of consumers in the marketplace. This does not happen in a vacuum, and depending on what factors in the, I think it's like a 7-part test that we could use to evaluate whether or not something is confusingly similar, it depends on the situation which of those factors come into play and which are weighed more heavily. So just because you don't find your exact mark that you're searching for in the trademark database, that does not mean that that mark is free to use. In fact, it may be unacceptable for you to use for a variety of reasons. This is why when you are considering a trademark, it's important to get a good search and to have that search properly interpreted in the context of the marketplace. And that's why you hire an attorney like me to do something like that. I'm Angela Langlotz, and I go live every weekday to talk about trademark law, other IP issues. You can find me online at TrademarkDoctor.net. And you can find me on Facebook at facebook.com/TrademarkDoctor. If you like this video, please share it if you think others might enjoy it. And I will see you tomorrow.